Appeals, Division 1, is now in session.
Good morning. Please be seated. It's the time set for argument in Mill Alley Partners versus Wallace, our civil number 13-0547. Each side will have 20 minutes within which to present their arguments. The appellant may reserve a portion of that for rebuttal. However, it's up to you to keep track of that time. We have read the briefs. We're familiar with the record and the issues raised here on appeal. So please feel free to take that into account as you make your arguments here this morning. We're recording the proceedings by digital audio, and so as you approach the podium, please identify yourself and your clients for us and for anyone else who may be listening. We're also recording the proceedings by video, and if you're really interested in what you look like on video, you can go to YouTube in a matter of weeks and check that out. With that, Counsel, may proceed.
Thank you, Your Honors. Good morning. Mary Hone for the appellant, and my client, Bill Wallace, is with me this morning at counsel table. I have elected to address the court's questions in the order that they were presented to us. First, regarding the final amended jury instruction, they did properly state the applicable law regarding the accrual date of a claim for breach of a guarantee agreement. Although the argument is academic at this point, because the statute of limitations instruction was not the basis for the lower court's granting the new trial, the final amended jury instructions were accurate with respect to the statute of limitations defense in Arizona. The Superior Court's 2012 ruling on the motions for summary judgment correctly pointed out that tenant Latshaw's breach of the lease triggered the accrual date for the statute of limitations. The final amended jury instructions mirrored the court's 2012 ruling, and the court's ruling is supported by Arizona law.
What law? What case is that?
That's Provident National Assurance versus Sobraco. It's actually a 1994 case out of this court, and in that case the court held the nature and extent of a guarantor's liability depends upon the terms of the contract. In this case, the terms of the contract, the guarantee provided that the guarantor would pay pursuant to the terms of the lease in the event the tenant failed to do so. In fact, the guarantee is page 36 of the lease. There was no liability on the guarantee apart from the lease. To make any sense, they have to be construed together. The final amended jury instructions, when read as a whole, correctly reflected Arizona law on that point. The last paragraph of the instruction on the statute of limitation highlights what the jury had to find in order to render a verdict on the legal issue with respect to the statute of limitations. And it states, if you find that the October 9th, 2009 lawsuit was filed more than 6 years after the Latshaws committed a material breach of the lease, you are directed to find for the guarantors. There has never been a case where this court or any other court has held that jury instructions have to be perfect. It's respectfully submitted by the appellant that the jury instructions given on the statute of limitations and otherwise, when taken as a whole, correctly instructed the jury on the law and gave them the proper guidance in reaching a well-informed and impartial verdict on the issues presented.
If we conclude that the amended jury instruction was correct, does that dispose of the appeal?
It does not, Your Honor. It doesn't really, because that issue isn't before the court. The question is still whether it was fundamental error to submit the equitable issues to the jury.
Well, how do we know why the jury ruled the way it did? In other words, given the general verdict, if the jury was properly instructed, the jury might have reached its verdict based on limitations.
And I think the jury did do that. I think, in fact, the jury did do that. I think based on all of the jury never heard any evidence whatsoever on the breach of the guarantee. The plaintiff will argue that there was one letter. That's the March 4th letter, or actually the April 5th, 2004 letter that was written by Mitch Resnick, the former counsel for the guarantors. And in that letter, he says that the guarantors refused to be held liable for any damages beyond March 1st, 2004. But March 1st, 2004 wasn't the first time that the guarantee was breached. That was what was attempted to be argued at in the lower court. But that wasn't the case. That was simply the cutoff date for the damages that the guarantors were taking responsibility for. And in fact, the landlord, the tenant, and the guarantors all considered the breach of the lease to be the key act when the guarantor's liability would kick in. And that's shown by the evidence that was submitted by the plaintiffs. That's the April letter, the demand letter, the May 2003 demand letter, and the May 6th demand letter that was sent to the guarantors. Those are Exhibits 2, 3, and 4 in our in the trial record. And those letters show that since April 2003, the landlord was always of the opinion that the guarantor was liable for all past due rent pursuant to the lease. Landlord wasn't holding the guarantor liable only for the lease payments after Latshaw abandoned the property on October 6, 2003. Rather, the demand letters that were sent to the tenant and copied to the guarantors requested past due payments, late charges, penalties, and interest from April 2003. And the demand letter that was sent directly to the guarantors, referencing the demand letter sent to the tenant, requested the same things.
Excuse me for interrupting, but does this issue that you're addressing right at the moment have anything to do, in your view, with the trial court's granting the new trial?
No, Your Honor. I don't believe that's why the court granted the new trial. I think the judge actually believed in, from his research, felt that the two instructions that went to the jury on the equitable issues created a fundamental error. I don't think he ruled based on the breach of the guarantee versus breach of the lease instruction that went to the jury.
What does our case law tell us about what may constitute fundamental error in a civil matter?
Actually, there's three very good Arizona Supreme Court cases that talk about fundamental error and define it. There's one in 1975, the Johnson versus Elliott case, 1988, Bradshaw versus State Farm Mutual Auto Insurance Company, and then 1997, Williams versus Thudy. And all of those, in the very first one, 1975, the Supreme Court does define fundamental error, and it says fundamental error has been defined as error which goes to the foundation of the case or which takes from a party a right essential to the case. And the Arizona Supreme Court doesn't waffle about that in the other cases. That's always the standard, whether a party has been deprived of a constitutional right. And, of course, it's our position that the plaintiff in this case was not deprived of a constitutional right. The plaintiff has a right to a fair trial. The plaintiff had a fair trial.
What about the fact that the equitable defenses here should have been determined by the court, not by the jury? They're given to the wrong body.
Well, the key to that question, Your Honor, is that the plaintiff never objected to the giving of those instructions. And the problem with that is it led defendants down a path that it otherwise wouldn't have taken. Had they objected to those instructions, obviously I would have moved forward with my motion for judgment as a matter of law with respect to the equitable issues. But because they were going to the jury, there was no reason for me to bring that up. Why would I ask the judge to rule as a matter of law when those issues are going to the jury? And we all agreed they were going to the jury. So,
well, if in a civil case, does a party who's arguing fundamental error need to also show that it was prejudiced by the error?
I think that is the key issue. That is the key issue,
So-
whether they were prejudiced.
So here, I'm just wondering, given the general verdict, how can Mill Alley show that the jury would have, the outcome would have been different had the jury not been instructed on equitable defenses?
I'm not sure how they're going to do that, Your Honor. I'm anxious to see as well. But I don't think they can show prejudice to themselves in this case. There was no prejudice to the plaintiff. The prejudice is going to be to my client if we have to retry this again. The plaintiff had more than ample opportunity to present its case. It had three things to prove: contract, breach of contract, and damages. We stipulated to the first two. We stipulated that there was a contract. We stipulated that there was a breach of the contract, and then they had to prove damages. They had to prove what the date of the breach was, and they had to prove damages. They took 2 days to prove the damages, and it still, at the end of that, was questionable what the damages were. But there was no doubt that at the end of all of that testimony, that the plaintiff was looking for late charges, penalties, fees, costs, and the payments from April 5th, 2003. And it was on that basis that we submitted to the jury that that was the breach date. If you're seeking the cost, the interest at 24% from April 5th, 2003, that's the breach date. And I believe that that is what the jury found. Our time in that at that trial was spent on the two legal defenses. We spent most of our time showing that the case was filed more than 6 years after the breach date, the material breach of the lease, and we showed that the landlord failed to mitigate its damages by sitting on its rights for the first 3 years that the property was abandoned. That was coincidentally the same amount of time that the lease was that the guarantee was valid. As a matter of fact, as soon as the guarantee was over, on October 25th, 2006, the landlord had the space released to Club Peso. That's Exhibit 36 in the court record.
Aren't we? I'm shifting gears a little bit here. Aren't we bound by a long history of cases to give substantial deference to the trial court when the court decides to grant a new trial?
Not as much as you are, Your Honor, to give deference to the jury verdict. And if there is any evidence on which the jury could have found that my client was not liable to the plaintiff, then I think you have to find and uphold the jury verdict and find that there was no abuse of discretion, that the jury was correct. And you can find that based on the evidence that was presented to the jury. You can find on the legal issues.
What if the evidence is technically sufficient, but the trial court looks at it and says, I think an injustice has been done here, and therefore I'm going to grant a new trial? And then our cases say that, when the trial court who sits there and we don't, when the trial court grants a new trial, we give a lot of deference, and we even give more liberal deference under those circumstances.
But, Your Honor, in this case, the thing that troubled Judge Gordon so much was those two jury instructions that went to the jury. And his finding was, and I think he's wrong, that because there isn't any law on this in Arizona that says that when you send two equitable issues to the jury by accident, then, and over no objection, there were no objections raised, then you have to retry the case. I know it troubled Judge Gordon, and I believe that, he was new to the civil bench at the time, coming from the criminal bench, and I wonder whether it just was a piece of his criminal background that there was something that was wrong, and I don't think it was that big of a deal in this civil case.
Do you think this is analogous to a situation where the parties, for whatever reason, litigate issues that are not contained in the pleadings. They litigate by consent.
I don't think that was the case here, Your Honor, because those two defenses, laches and equitable estoppel, were raised in the pleadings. We didn't hit them hard at the trial, though. They were, just included in our jury instructions, and nobody objected, and they went to the jury.
None of the jury questions addressed or pertain to these two defenses?
None of the jury questions pertain to those issues, no.
And there were no objections to the actual language of the instructions as given?
Correct. There are no objections to the language, no. We concentrated on that statute of limitations jury instruction.
What evidence was there of a material breach? I'll put different. What evidence supported? And I see you're down to 5 minutes. What evidence would have supported the jury finding in the defendant's favor on limitations?
That's all the evidence that we presented of the breach of the lease.
Material breach?
Material
before
breach of the lease. That was the lack of the late payment in April, late payment in May, no payment in June, no payment in July, and then they worked out a deal, and then the very last payment, partial payment that he made, and the testimony came from plaintiff's witnesses, the last payment was October 6, 2003. And there were no more payments made, and Mr. Latshaw abandoned the property. So all of that evidence was before the court on the before the jury on the statute of limitations issue. That's a legal issue.
10th is the date that the complaint was.
October, yes, in 2009, correct. And we contend that October 6th, 2003 was the last material breach.
Okay. Thank you.
Thank you, Your Honors. I'm going to reserve the rest of my time.
All right, thank you. Counsel?
Thank you, Your Honors. My name is Jennifer Perkins. I'm here on behalf of the appellee, Lawrence Cutler, who's at the table here, and Robert Mandel is with me also. Need to correct an error that just occurred that's actually quite fundamental, and that is that the date that this lawsuit was filed was October 9th, 2009, which, depending on the way you go with things, could be a fairly important mistake to correct. The trial judge in this case did not abuse his discretion in granting Mill Alley's request for a new trial for two main reasons. Giving the jury equitable defense instructions was fundamental error. Further, that error was highly prejudicial to Mill Alley in and of itself, but it was also substantially exacerbated by the erroneous amended instruction. It is crucial for the panel to recall that you are not evaluating whether you would have reached the same conclusion as the trial judge, but whether his conclusion as to the granting of a new trial was an abuse of his discretion. This means you need to consider the whole context of the trial. As noted a few moments ago, the standard of fundamental error is error that deprives a party of a fair trial. So we don't look at something in a vacuum. You must look at the whole trial and find out whether this error, this clear error of submitting the improper instructions to the jury in that context of the trial amounted to a fundamental error that deprived Mr. Cutler and his business of a fair trial.
It is clear error, but they got a trial with a finder of fact. It happened to be the jury instead of a judge. How is that fundamental?
Well, we need to look at all of the circumstances surrounding those improper instructions to the jury. There was really a cascading sequence of events that in the aggregate cannot be interpreted elsewise. First, there was a mid-deliberation re-instruction of the jury with substantial alteration of the instructions.
On the statute of limitations?
On the statute of limitations. Second, that mid-deliberation re-instruction required a re-argument by the parties, and that re-argument came to the jury after they had to wait 4.5 hours in the jury room, having been instructed to cease deliberations. At that point, they received an amended instruction, the limitations instruction, that was both factually and legally flawed. it was factually flawed because it had a circular erroneous date in the instruction. I think it's important, we heard the last paragraph of that instruction, but it's important to hear how the instruction reads. It causes you to read it 2 or 3 times for anybody that sees this for the first time. Guarantors have raised as a defense to plaintiff's claim for breach of their guarantee agreement, alleging that it is time barred because plaintiff did not bring its suit within 6 years of October 9th, 2009, which is the date the lawsuit was filed. We have various issues there. One of the crucial issues is not just that that was a mistake, but that it's a suggestion from the trial judge to the jury that October 9th was the crucial date when it was actually October 10th. October 10th was the date of the lessor's breach.
Oh, that
which,
language was in the original instruction.
This erroneous language was in both.
Yeah,
The original.
The reference to October 9th was in the original.
Right. So on 2 occasions, the trial judge instructed the jury improperly factually. The second occasion is where
But before you leave that, if you can hold your place mentally.
Sure.
I assume that counsel, in arguing to the jury, made it clear that we're talking about was the lawsuit filed within 6 years or not?
Well, unfortunately, it appears that no one in the trial court recognized this error. So they did argue whether or not the statute of limitations was 6 years and whether it was filed within 6 years. The problem is tying that factual error to this legal error. And that's really the base that sort of makes the factual error even more problematic, is that the jury should have never been looking at the date that the tenant, the Latshaws, breached the lease. They should have been looking at when the defendant's breach occurred, which was not at the same time.
Well, tell us what the legal support, why it's wrong legally, given the language of this guarantee, which didn't require demand or notice.
Sure. The instruction, by providing that, tying the accrual date to the Latshaw's breach, suggests that if Mill Alley had brought its suit against Wallace on October 10th, 2003, for instance, it could have recovered all of its contract damages at that time, and regardless of whether or not he refused to perform under the guarantee agreement. Arizona law is clear that a guarantee contract is separate from the underlying contract, whatever it is. Mill Alley predicated its claim against Wallace on Wallace's breach of that guarantee, not the breach of the lease. His breach had to have occurred after the Latshaw's breach. It was just wrong for the trial court to instruct otherwise. In addition to the evidence in the record, which we will get to, I know we had some questions about that, that Wallace's breach of the guarantee occurred later. It would have been impossible as a matter of law for Wallace's breach to occur contemporaneously with Latshaw's breach because he had an implied contractual right under Arizona law to try to cure. Judge Johnson, you pointed out in the Quiroz versus Harvey. Maybe we should just refer to that as the Harvey decision. And what you were pointing to now, that was a decision that was vacated, but it was vacated on other grounds, and the principle that you pointed to there was a principle from the restatement of contracts, from Farnsworth on contracts. It's a general principle in Arizona law. A party that has materially breached a contract is given a reasonable period of time in which to cure, even if the contract contains no express cure provision. And that is why legally Wallace's breach could not, it's just not legally possible for it to have occurred that same day unless we're throwing out this principle of law saying even if he had breached that day, he would have been given a reasonable opportunity to cure before it would be considered a material breach upon which damages could have been assessed.
Was there discussion in the trial court, either with the court at the instruction phase or with the jury during summation about that point, about the guarantor had a reasonable period to cure and didn't breach until it failed to cure?
Not in so many words, but yes, effectively. And the reason is that there is testimony in the record from Wallace himself that he did not view it as a irreconcilable position, as a final breach until that April 5th letter that we just heard about. His testimony on day 3 of the trial, pages 100 to 103 of that transcript, again at 110, he testified that there were ongoing negotiations, that both parties viewed this as there still being an opportunity to cure. Mr. Wallace testified to that, Mr. Cutler testified to that, and both of them pointed as a final turning point to Trial Exhibit 31, which is that April 5th breach letter. The jury repeatedly, from both of those witnesses, heard that the parties intended to work this out, that they intended to have Mr. Wallace perform on the guarantee contract separate from the lease, now that his obligation was incurred, up until he said, no, I refuse to perform, which the final statement was again in April 2004.
Turning to the other half of the case, what do we do with the cases such as Long, and Johnson, I believe, that say that the fundamental error in the civil context requires an error of constitutional dimensions? What right does a plaintiff have under the Constitution to have equitable defenses found by the jury?
I think the greater right is the right to have the fair trial, and that is the basis of the fundamental error. The erroneous instructions, the erroneous equitable instructions, confused the jury, presented to the jury a picture of the scope of their duties that was just flat wrong. It changed the entire context of what they believed their role as the jury is. The right to trial by jury is a constitutional right. It's a fundamental right. And that is why this is fundamental error, to have interfered with that right by taking away the appropriate parameters for the jury's analysis of the case. By telling the jury, you have to find all of these legal defenses, which are not really your job to find. And I guess that's where it's an appropriate time to talk about the question that the panel had asked about the prejudice that Mill Alley incurred as a result of these equitable defenses going to the jury. Basic legal error is inherently prejudicial to the party for whom the error goes against. But beyond that, as noted, this changed the scope of the jury's duty, and it changed the tenor of the entire jury instructions to become sort of defendant-centric jury instructions. The focus of the jury at this point was whether or not Mill Alley did something wrong, not whether or not the party that admittedly breached the guarantee agreement that was the subject of this trial did something wrong.
Well, wouldn't the jury have received the same instructions had its verdict on equitable defenses going to be only advisory?
I'm sorry if it...
I kind of speaking Yoda speak here. What normally happens when a party raises equitable defenses in a jury trial is that the jury is instructed, but its verdict is only advisory to the court. So my question is, wouldn't the jury have received the same instructions to guide that determination had its verdict been only advisory?
That's a good question, Your Honor. I suppose the hypothetical, that might be something that's appropriately addressed if this goes back on a new trial, as Judge Gordon intended for it to be, that this should be done correctly in a new trial. The issue with the prejudice is not just those two instructions themselves. They are the crux of the error that Judge Gordon found to be fundamental error, but they have to be looked at in the full context. And that's where I do think it's appropriate for the panel to consider whether or not that those two instructions being given improperly in their entirety and as a final conclusion alongside such an incredibly flawed limitations instruction that was not only flawed once but twice.
Well, if I'm following you correctly, and at the risk of oversimplifying, you're arguing that this all created confusion.
Yes.
But if I understand what the judge did, he rejected any confusion argument. He simply said these two issues, happen to be equitable defenses, should not have gone to the jury.
Well, what he rejected was the argument that the limitations instruction was flawed. He disagreed with that, which is understandable because although his ruling changed forth and then back on the limitations instruction, that was his ruling and he was sticking with it. But this court has a de novo review of legal issues. So as to if you're looking at the limitations instruction as to whether or not that instruction was legally proper, you have a de novo review. And I think if you take a look at that de novo review, you will find that that instruction was legally improper. Once you find that, then you...
He didn't find that, though. So I
He
guess
didn't.
this is part of your argument that we should we should affirm his grant of new trial on a different basis than he granted it.
No, I think you should affirm it on the basis that he granted it, but I think you can affirm it also on a different basis. And that kind of goes to the fourth question that the panel asked, which is, may you or must you affirm if you find either that the limitations instruction was legally incorrect or that there was fundamental error. Now, certainly, it's fairly clear that if you do find fundamental error, you must affirm the grant of the new trial.
Fundamental error in regard to the equitable defense.
Instructions, right.
Well, why is that? Because, I mean, how can we know that your client was prejudiced by the equitable defenses? It could very well have found for the defendant based on limitations.
I think the issue is that we're in a little bit of a circular argument, and that's the issue. Fundamental error, by definition, is error that resulted in an unfair trial. That's prejudicial. So prejudice is not actually technically part of the fundamental error finding. It's there. You can find prejudice here. We've discussed a little bit of how prejudicial this was to Mill Alley, but you do not need to make a separate prejudice finding. Fundamental error is prejudicial by its very terms. If an error is fundamental, it is prejudicial to the party whom suffered the error. And I think that's the must part of question 4B, I guess I would call it, from the panel. The panel, if you find that fundamental error occurred as a result of giving the improper instructions, then you must affirm. The other sort of sub-answer to that would be, again, the standard of review before you, as Judge Gemmell noted at the beginning of this argument, is an abuse of discretion standard, and the court has been fairly clear in saying, and I guess it was Judge Gemmell himself that has made that statement before in the McBride v. Kickofer Associates, you apply a more liberal standard when you're considering a grant of a new trial rather than a denial of a new trial. So the grant...
I didn't make that up, though. I was borrowing it from some other case.
But you said it so well, I had to bring it up.
The liberal part.
Right, right. Well, and I think that takes us back to the point that Judge Winthrop made in the Cal Extra opinion, which is, and you mentioned it at the beginning of this argument as well, the trial judge sees the witnesses, hears the testimony, and has a special perspective of the relationship between the evidence and the verdict, which cannot be recreated by a reviewing court from the printed record. While Judge Gordon's affirming order affirming the grant of the new trial limited that decision to one reason, he didn't reach that decision in a vacuum. He reached that decision in light of the entire context, the 4-day trial that he sat in, the 4 different prejudicial factors that were this confluence of events, the mid-deliberation re-instruction, mid-deliberation re-argument, having the jury start deliberations, cease deliberations for an extended period of hours, and then sit back down.
You're speaking to this question I have, that I kind of wonder if he didn't have a greater concern about the overall fairness than he ultimately expressed.
I believe he did, and I think the issue is that the specific bases that were before him on the motion for a new trial were articulated most clearly as this amended jury instruction on limitations and the equitable remedies. The parties did discuss in some form the irregularities of the trial, but that wasn't, at least to my recollection, a separate articulated basis. And I think that was really the underlying theme, if you will, that Judge Gordon was dealing with in looking at the equitable remedies, recognizing that there's no question that was legal error, recognizing that it occurred in this context of really some fairly serious irregularities, and added into that, while he didn't see the amended instruction as legally erroneous, this panel has the opportunity for a de novo legal review of that instruction, and based on the cases that make it pretty clear a guarantee contract is separate from the underlying contract and the statute of limitations is assessed separately, then there's sort of no question but that this has to be fundamental error. There was no fair trial that occurred. And I think one point I'd like to make is there was a statement made earlier about giving deference to the jury's verdict, and I think that might cause a little bit of confusion. This panel is not being asked to overturn the jury's verdict. You're being asked to offer a new trial opportunity. Both parties will still have the opportunity to argue. There's no guarantee that Mr. Cutler and the Mill Alley partners will be successful on a new trial. The idea is that they will be given a fair opportunity to reach a successful verdict. This is not before the court on a judge overturning the verdict. This is before the court on a grant of a new trial. And so this panel's framework is that abuse of discretion standard with the liberal view of Judge Gordon's ruling, given the context in which he made that ruling. I am actually finished with my argument unless you have any further questions.
Nope.
Okay. Thank you.
Just a few points, Your Honors. First, I want to clarify that the jury was not waiting in the courtroom for 4 hours that day. Judge Gordon released them and told them what time to come back and told them that we would be re-arguing or redoing our closing arguments at that time. So they weren't just sitting around waiting. But I wanted to, it's really illogical to argue that the statute of limitations can be disconnected from the lease. The guarantee doesn't exist without the lease. There isn't just a guarantee. It's tied to the lease. And the language in the guarantee actually just cements that.
What about the argument that everyone acknowledges that the guarantor has an opportunity to cure and therefore cannot have breached until failed to cure?
It's a brand new argument, Your Honor. That was not presented to the jury. There was no evidence that went to the jury not on the cure. That there was evidence with respect to how my client did attempt to cure the breach, but the material breach didn't change by the fact that my client was trying to fix it. The material breach was the same. The lease itself says that the material breach is a default is if you fail to pay the rent on time.
Well, that says what a default is, but I don't think it says that's what a material breach is.
True, which is why we gave it to the jury, because they had to define it and give us that date. And we gave them so many dates for material breach of the lease. It just there was so much. There was overwhelming evidence about the breach of the lease, and this is the point that troubled Judge Gordon. And this is the jury was waiting for it. The jury was waiting for their instruction with respect to the statute of limitations and the breach of the lease. The fact that it was wrong the first time is what created the problem, because at the very end of the trial, Judge Gordon reversed himself, changed his thinking that he had already put into the motions for summary judgment. We argued the whole case based on his ruling on the motions for summary judgment, that the breach of the lease by Latshaw triggered the statute of limitations. That was all given to the jury. So when the jury got the instructions, they couldn't find the piece that said how does a guarantee get breached. That's when we got questions 6, 7, and 8. And that was at the end of the day on day 3. We fixed it all and redid the instructions, re-argued our closing arguments, and the jury had its verdict within 20 minutes of beginning deliberations. They were waiting for the correction. It was a very intelligent jury, and they corrected the damages calculation. They listened to everything. They knew what was going on. They knew that the 6-year statute of limitations was in place, that it was going from some date that they determined to October 9th, 2009, when the complaint was filed. That date was thrown around the whole time. How we put October 9th, 2009 into that first paragraph of the statute of limitations instruction is beyond me. I think we had 5 attorneys and 1 judge working on it. But obviously, the jury wasn't focused on that paragraph. The jury was focused on the rest of the statute of limitations instruction, which said that you have to find the date that Latshaw materially breached the lease. And that is the only date that matters. And then they came back with a defense verdict. I don't think we have to do it again. There was 4 days of trial. The plaintiff had plenty of ample opportunity to present its case, and took all of those opportunities, had an opportunity to present evidence on the breach of the guarantee, didn't do it. Had opportunity to object to the giving of the equitable instructions, didn't do it. I don't think we have to retry it.
Thank you, counsel.
Thank you.
Appreciate the arguments here this morning from both sides. We will take this matter under advisement and issue a written decision in due course. With that, we are adjourned.